Well, hello and welcome to today's webinar on effective performance management. My name is Jeanette Lucas. I'm a partner in the Labour and Employment team in London, and I'm joined today by my colleague Will Saunders, who's one of our senior associates. Just before we get started, I'd just like to make a couple of quick housekeeping points. First of all, throughout today's webinar, all participants will be in listen-only mode. Having said that, there is a Q&A function on your screen, and if you would like to raise questions at any time during the session, please do that. And you do that by selecting all panelists from the drop-down list. That said, we do have quite a lot to get through today. If we can get to your questions, we will, but if for any reason we can't, then rest assured we will follow up after today's session and deal with those questions for you. We'll also be circulating the slides and a link to a recording of today's webinar if you want to share that with colleagues or if you want to listen back later. So what are we talking about today, or why are we talking about it? Well, the reality is that performance management really continues to be an important focus and issue for employers, as is clear from the number of you who signed up for today's webinar. And I think to some extent, the issues have become even more pronounced with the continuation of hybrid working post-COVID and the additional challenges that that can sometimes bring. Although generally speaking, employee performance and having to proactively manage it is usually restricted to a small number of your team, that nevertheless doesn't stop it being something which takes up a huge amount of management time and energy trying to deal with. And the aim of our session today is really to try and provide some practical advice around the key issues to be aware of when you are either managing performance yourself or you are supporting your managers in doing so. So we'll start off with a reminder of some of the basics. So the key steps to take when you're managing poor performance. We'll then move on to think about some of the most common mistakes that managers make during these processes and how you might avoid them, before finishing off by looking at some of the practical issues that sometimes arise during these processes, including the employee who raises a grievance, who goes on sick leave, or who raises health or potentially disability issues. So on that note, I'd like to hand over to Will, please, to get us started. Will.
Thanks very much, Jeanette, and good afternoon, everyone. So, before we get into the mechanics of managing performance in the workplace, it's worth jumping ahead, beginning with a potential end in mind, and reminding ourselves of what exactly a tribunal would expect to see if a dismissal for poor performance ended up in litigation. So, at a very simple level, as per the slide, from an unfair dismissal perspective, the basic equation is fair reason plus fair procedure should equal fair decision. So, what would the fair reason be in a performance dismissal situation? Well, as we should know, under the Employment Rights Act 1996, capability is a potentially fair reason for dismissal. Capability in relation to an employee means his or her capability assessed by reference to skill, aptitude, health, or any other physical or mental quality. So, it's a broad definition which covers things such as lack of productivity, inability to reach company standards, inability to establish good working relationships with colleagues or customers, and inflexibility, for example. In all unfair dismissal cases, the burden of proof is on you as the employer to show that capability was the genuine reason for dismissal. That means that the employer must honestly believe on reasonable grounds that the employee is incapable or incompetent. It must also be reasonable for the employer to have dismissed the employee on the grounds of capability in all the circumstances of the case. Now, it's not possible to provide an exhaustive list of all the factors that could be relevant for this purpose, but case law has established that in assessing whether a dismissal was fair, a tribunal may consider circumstances such as these. Whether the employee was aware of the expected standards and the improvement that was required. Whether any targets the employer set the employee were reasonable. That clearly doesn't mean that they must necessarily be achievable by this employee, but they're unlikely to be reasonable if they wouldn't be achievable by anyone. Whether support was given to the employee to meet the required standard. the reason or reasons for the underperformance. It's less likely to be reasonable to dismiss an employee where the poor performance is for a temporary reason, which is likely to pass in the foreseeable future. Whether a fair procedure was followed prior to dismissal, of which more to come later. The employee's length of service. As a rule, the longer employees have been employed, the longer you're expected to allow them to correct any underperformance. Although the flip side of that is, arguably, longer-serving employees should have a better understanding of the level of performance expected, and therefore arguably less excuse for failing to meet it. So it can cut both ways. Finally, whether the employer considered alternative employment, such as a less demanding role, or one otherwise better suited to the employee's skill set. That may also be relevant. So, of course, many employers have written formal performance management procedures in place, which is almost invariably a good thing, provided the procedures are well designed and any policy documents are well drafted, because this helps to ensure that managers deal with employees fairly and consistently. I say that written procedures are almost invariably a good thing because if an employer's performance management processes aren't well thought through, they may, of course, serve only to entrench bad practice. But that aside, it's generally important that employers seek to comply with their own policies and procedures so far as circumstances permit. However, that said, we would strongly recommend that performance management policies, and indeed all your policies, shouldn't be contractual. Having contractual policies in place can unhelpfully tie an employer's hands and could lead to breach of contract claims and ER issues if an employer seeks to amend or otherwise depart from them. Whilst the failure to comply with your own processes won't necessarily render a dismissal unfair in all cases, a tribunal will inevitably take this into account when reaching its decision. Employers should therefore depart from their own policies, even when they are non-contractual, only when they have a legitimate and reasonable basis for doing so. In addition to any internal policies, the ACAS Code of Practice on Disciplinary and Grievance Procedures outlines the process that an employer should follow. The ACAS Code applies in disciplinary situations, which for this purpose includes action taken because of poor performance. That means that employers should almost always comply with the minimum procedural steps set out in the code. As a result, your own performance management procedure should ideally be drafted with the code firmly in mind. Turning to the contents of the code sets out 6 general principles with which employers should comply wherever a disciplinary process, including a formal performance management process, is being followed. These are, first, raise and deal with issues promptly. Don't unreasonably delay meetings, decisions, or confirmation of the outcome of meetings. This is one of those things that managers are most likely to get wrong. People are often unwilling to deal with underperformance promptly and effectively. After all, no one likes having difficult conversations. However, it's invariably better to manage performance issues promptly as and when they arise, rather than sticking your head in the sand, crossing your fingers, and hoping for the best. It can become progressively more difficult to take action in relation to underperformance which has gone unaddressed for an extended period of time. And if the performance is such or becomes such that the business ultimately decides it would prefer to part ways with the employee altogether, the process of doing so will generally be significantly more time-consuming and costly when no formal action has previously been taken. The second ACAS principle is that you should act consistently. So, faced with a similar set of circumstances, the business should generally respond in a broadly similar way. That means that if you want to depart from an approach taken in a previous situation, you should really be able to justify that decision by distinguishing the circumstances of the two cases in some way or other. Third, you should carry out any necessary investigations to establish the facts of the case, such as the nature, extent, and duration of the underperformance, and the reasons for it. That will ensure that the decision maker has all the details necessary to make a fully informed decision. This is another area in which managers often fall short. As we know, a manager often, quote-unquote, knows that an employee is underperforming, but is not necessarily able to provide documentary evidence to support this, or the evidence available may show an inconsistent pattern. With this in mind, it's very important that appraisals, for example, are an accurate reflection of the employee's performance during the relevant period. A quote-unquote satisfactory rating may well be intended by a manager to really mean unsatisfactory when used in an appraisal, but a tribunal probably won't see it that way. The key point is that if an employee's performance has been inadequate, you should ensure that there's a paper trail that reflects this. The fourth ACAS principle is that you should inform employees of the basis of the problem and give them an opportunity to put their case before any decisions are made. There may well be a reasonable explanation for a temporary period of apparent underperformance, and you should be seen to take into account any representations the employee makes before taking any action. Fifth, as with disciplinary hearings related to conduct issues, you should allow employees to be accompanied by a colleague or trade union official at any formal performance management meetings. Finally, the ACAS code says that you should allow an employee to appeal against any formal decision made. Best practice would be to inform the employee of the right of appeal when the decision is communicated. If the employee does appeal, the appeal should ideally be heard by a manager who is senior to the original decision maker, and in any event, someone no less senior, so that there can be no doubt about the appeal manager's authority to overturn the initial decision. The appeal manager will need to consider the grounds of appeal, meet with the employee at an appeal hearing, at which the employee also has the right to be accompanied, conduct any further investigation as may be required, before providing a fully reasoned outcome in writing. So the sting in the tail is if employers unreasonably fail to comply with the ACAS code, this could result in an unfair dismissal claim, and if the claim was successful, to an increase of up to 25% in the compensation awarded. This provision does cut both ways, however, and a reduction to compensation may be made where it's the employee who fails to follow the code, by, for example, unreasonably failing to attend a formal meeting when requested, or declining to exercise the right to an appeal when offered. That's another reason why it's advisable to always inform the employee of the right to an appeal when the decision is communicated. Could I have the next slide, please? Thank you. So, just how poor must poor performance be? In order to manage underperformance, a manager needs to have a clear understanding of what the baseline performance looks like. Ideally, this should be measured by objective criteria, such as monthly sales targets, for example. However, not all roles lend themselves equally to being assessed by reference to objective criteria, and subjective criteria may well also be relevant. Once you know what the employee's performance should look like, you can determine whether they're underperforming or not, and, if so, to what extent. If, for example, employees are only narrowly missing their monthly sales targets, this may not trigger the performance management process, at least not initially. If employees are ahead of their annual sales targets, for example, the fact that they may be below budget for a few months may not be an issue. The applicable trigger points of formal action may take into account factors such as the extent to which an employee is below target, either in absolute or percentage terms, the frequency with which targets are missed, and whether the employee is on track to achieve any longer-term targets or goals. Managers should also consider whether there are any other possible causes of poor performance, responsibility for which it may not be fair to lay at the employee's door. For example, underperformance may be caused by factors such as poor systems of work or inadequate procedures, poor quality or inadequate supervision or support, unclear instructions, an excessive workload, or external stresses. You should therefore not assume that just because employees are underperforming, it's necessarily their fault, even if that's their manager's provisional view. It may be that other things are to blame, in which case it may be appropriate for a manager to take an employee down the performance management route only after taking other steps first. Other measures, such as further training or support, may be more appropriate in the first instance. It's important to bear in mind that taking such measures initially doesn't mean that you couldn't take a different stance at a later date if the underperformance continued. Indeed, taking firmer action at some point down the line is more likely to be considered by a tribunal to be appropriate if you first provided as much support as you reasonably can. On a separate point, when assessing an employee's poor performance, managers should always consider whether it's really a case of can't do or if it's actually a case of won't do. If it's genuinely a case of can't do, then the employer should comply with its performance management procedure and offer any support and training as may be appropriate in the circumstances. However, if it's really a case of won't do, then it would usually be appropriate to take action under the disciplinary procedure, potentially resulting in a warning for misconduct. The test for this purpose is always whether the employee is choosing not to do what's required. Let's now discuss the key points to remember when managing performance. First, ensure employees are aware of the standards expected of them. As we've already mentioned, it goes without saying that it's important that employees are aware of what's expected of them. Once you're clear in your own mind about what an employee's performance should look like, whether by reference to objective criteria, if available, or subjective criteria, where appropriate, you should ensure that you clearly communicate this to the employee. Apart from anything else, that will ensure that ignorance of the required standards won't be an excuse reasonably available to the employee in the event of underperformance. Second, in the event of underperformance, warn employees and give them an opportunity to improve. Although underperformance can sometimes be successfully handled informally without any warnings, performance management policies generally provide that if an employee is underperforming, the company can take formal action under the procedure. This will usually involve holding formal meetings with employees to discuss their underperformance and, where appropriate, issuing formal warnings. Any warning should clearly state the nature of the underperformance, the level of improvement required and how it will be measured, the time limit for achieving the required improvement, any training, equipment, facilities, supervision or support that the employer will provide to assist the employee to achieve the necessary performance, and the potential consequences if the employee fails to achieve or maintain the required standards of performance. As with many areas of people management, preparation is the key to a successful performance management meeting. Prior to a meeting, managers should ensure that they're very clear about the performance issues they want to address and how they're going to set out their concerns. If at all possible, they should have specific examples of the employee's underperformance, including any relevant paperwork, such as recent objectives or appraisal documents for reference. Managers should also think about how the employee is likely to react when the underperformance is raised. Some employees may become defensive, in which case it may be especially helpful to be armed with specific examples of poor performance. Other employees may become upset or anxious about their ability to meet the required standards, in which case it may be helpful for the manager to be ready to reassure the employee and emphasize any additional support that will be provided. Managers should also think about what targets the employee needs to hit to improve, as well as the timescales for doing so and any consequences of a future lapse in performance. We'll discuss shortly what a reasonable review period looks like. The third point on the slide is that before dismissing, the employer should consider alternatives, including alternative employment. Ultimately, if an employee's performance doesn't sufficiently improve following a series of warnings, the employer will have to consider dismissal. However, before taking a decision to dismiss, the employer should first meet with employees and give them an opportunity to present their case, as you would before any dismissal, at least where the employee qualifies for the right to claim unfair dismissal. As I mentioned previously, it's important that you comply with the ACAS Code of Practice unless it's reasonable not to do so in the circumstances. As part of this, an employment tribunal would expect an employer to consider whether there are any alternative positions that an employee could do before proceeding to dismissal. Employers are not under an obligation to create a new role, but if there's an existing vacancy that the employee could do and may be prepared to accept, the employer should offer this prior to contemplating dismissal. Please note, however, that the employee can generally not be forced to accept a different position. If you wish to have the ability to unilaterally demote an employee in the case of underperformance, you would need to have an express contractual right to do this, for example, in the employee's contract. Finally, always keep a paper trail. So it's very important that you retain written records of the steps you've taken to manage an employee's performance. Such documents will be crucial if the matter ever ends up in a tribunal and the business is called upon to defend its approach to managing the employee's underperformance. I'm now going to hand back to Jeanette, who's going to look at some frequently asked questions, starting with what a reasonable review period looks like.
Thanks, Will. Well, rather unhelpfully, you might think, the law doesn't actually specify a time frame for improvement. So it doesn't say anywhere, for example, that you have to give an employee 6 months or so within which to up their game, so to speak. The reality of it is that the timescale that you need to have in mind is the one that is reasonable in the circumstances. And the sorts of things that you would take into consideration there would include some of the things you can see on the slide there. So first and foremost, the nature of the employee's job and how quickly it will be possible for the employee to demonstrate the required improvement in their performance. And that will depend very much on the nature of what they do, because in some cases, the improvement might be more obvious more quickly, but in other cases, it might take longer before they can really address or show that they have addressed the performance concerns. For example, it might be, I don't know, in a cold calling or something like that. If they have a daily target for calls that they're required to hit and they keep missing it, then that might be something that you could apply a shorter review period to, because it ought to be obvious quicker whether or not they are improving their hit rate, so to speak. Alternatively, there may be other roles where it's much harder to measure improvement over a week or possibly even a month. It can sometimes be longer, and that necessarily means that the review period will be longer as well. Employees' length of service. There's generally the view that longer serving employees may need to be given longer to improve. And that's particularly the case if up to this point, previous performance has been pretty good. It's really a question of giving them some additional leeway to take account of the fact they have, until that point, otherwise been a good performer and a good employee. The other thing that you should consider as well is the employee's personal circumstances. If, for example, you know that an employee is perhaps having personal problems outside of work that might be having an impact on their performance, then again, that may justify giving them a longer period of time to improve. I mention this because actually in the last 12 months or so, we've certainly seen more clients raising this with us when they are dealing with the performance management issues. And that could be for any number of reasons, I think, but it does seem that there are an increasing number of employees who appear to be struggling with issues outside of work that then do impact on their performance at work. It's worth remembering also that if you have an employee who has a disability, that you may also need to consider reasonable adjustments as part of your performance management process, which may also have an impact on the review period that you need to put in place. And I'll come back to that in a minute. There's also a question about the seriousness, the gravity, the extent of the poor performance, which Will's touched on already, but really how far behind the required standard are they? And also, what are the potential consequences of their underperformance? If the business impact is material, then it may mean that you are able to justify a shorter review period. On the other hand, if really the impact is very limited, then that might be more difficult. Another factor might be, or another consideration, and again, Will has mentioned this, is your own policies and procedures. What do they say about the suggested time frame for improvement, and what level of help will be offered and given by the business? And again, that will depend on the circumstances and whether or not, as part of your discussions around the performance, you've identified some sort of training need. But it's always good practice, if you are going to deviate from a suggested time frame contained in your own policies and procedures, that you are able to explain the reasons for that, to avoid any argument further down the line, or even at the time, that you're treating them less favourably than others for some potentially discriminatory reason, for example. Another factor could be whether, and if so, for how long, the employee has known about the problems about relating to their performance before the formal process has started. So, I mean, obviously, it's not uncommon for there to be various informal conversations. It might have been brought up in one-to-one meetings, during appraisals, for example, and that can certainly have an impact on how much longer you should give them to try to turn things around. As I've said, in certain circumstances, it might be that a few weeks is long enough, but in other cases, it will be a question of giving them months, particularly if there is some additional training that's required, because obviously then you will need to give them an opportunity not just to have that training, but to enable them to show that the training has had an impact. And it's not unusual really for review periods to be somewhere between 3 and 6 months. A really, really important factor though is that during any review period, irrespective of how long it is, you've got to make sure that there is a robust process in place for continuing to monitor the employee's performance during the relevant review period. It is not impossible, and certainly we have seen some cases where it becomes clear very quickly that the employee is simply not going to be able to reach the level of performance required. That tends to be the exception rather than the rule, so I'm certainly not advocating that as a general approach. But again, it very much depends on the nature of the role, the extent of the underperformance, and the extent to which they've had support and assistance in trying to resolve the issues before you get into a formal process. In terms of target setting, you need to be a little bit careful there. Ideally, they need to be objective targets, but you need to strike the right balance between objectives that stretch your employees but are not unrealistic relative to others. You've still got to make sure that your expectations are consistent. And again, this picks up on something Will said before about consistency in treatment. It is possible to argue that if an employee has agreed to the objectives that you set, then a failure by them to meet those objectives is arguably less excusable, but it certainly does not automatically mean that any subsequent dismissal would be fair. It is not and equally, you don't have to agree those targets as a prerequisite for a fair dismissal. What do you do about an employee who ups their game in the short term, but then once you're through the review period, it drops off a cliff again? Well, I mean, let's face it, I think we've probably all seen it in one way, shape or form. In those cases, I think it would be appropriate to issue a more serious warning, so perhaps escalate to the next level of your performance process, and consider also extending the period during which that warning would apply, even if that's beyond your standard process, because you would have a clear explanation as to why they have or why you have done that. And it is reflected in the need that it isn't just enough to meet the performance objectives, they have to sustain that performance moving forward. And as I've said, it's important if you do that to explain clearly to the employee why that is. Again, just to ensure that you're able to deal with any allegations that they might make of some sort of unfair or discriminatory treatment compared to others. So, moving on then, how do you handle an employee who claims that they're experiencing poor mental health or that they have a disability and that this has, or that's the reason why they have been underperforming? Well, the fact that an employee says that they may be having mental health challenges does not in and of itself mean that the company can't deal with their underperformance. That said, it does mean that you need to be sympathetic, at least to their current situation, and be seen to take reasonable steps to support the employee if you want to try and get the best out of them to maintain that positive working relationship and avoid the risk of a claim. Similarly, the fact that an employee has a disability or claims to have a disability does not in and of itself mean that you can't deal with underperformance either. Obviously, if they are known to have a disability, then you need to make sure that you are considering reasonable adjustments. But it does not mean that you cannot address the underperformance issue. So it may still be appropriate for you in the circumstances to issue a warning, particularly if you have considered the reasonable adjustments that you can take, and those reasonable adjustments have had no positive impact on the performance. In either of those circumstances, the start point really for the employee's manager is to get more information about what it is the employee says is causing them difficulty. And to be honest, this is something that in and of itself can sometimes make managers quite nervous about, because they are understandably, I think, nervous about saying or doing the wrong thing, especially if they are concerned that that might later be held against them, or that the manager might be said to have caused the problem by, I don't know, giving them too much work or something similar. However, all the advice that we have heard from medical practitioners, mental health charities, etc., is really that having an open, honest conversation about mental health is the best thing that you can do if you want to support an employee who is genuinely experiencing mental health problems. So, for example, if you have an employee that claims they are experiencing stress, anxiety, low mood, then ideally what you should do is try to get some more information from them, from the employee initially, and in particular to try and understand and discuss with them why they feel that that is impacting on their ability to do the job. You might try and explore with them whether or not the causes for their stress and anxiety are work related, or whether or not they are factors outside of the workplace. If they are work related, is there anything that you could sensibly, reasonably do that might help deal with them? Is it a question of too much work? Is it training need? Is it some other support that they would need to try to improve things? And that is not to say that anything that the employee asks for you should agree to, but it may well be that there are some fairly small adjustments that could be made that might actually have quite a significant impact, particularly if taken together. You might also want to think about what other support is in place for employees who may be struggling for whatever reason, mentioning to them the EAP or Employee Assistance Programme, or anything like that you may have within your organisation. In some cases, it might be that you ought to get appropriate medical advice, in part to understand whether the mental health issues are affecting their performance in the way that it's reasonable that their mental health issues are affecting their performance in the way that they say. But you can also see guidance from them in terms of the steps that you might take to support the employee. It may well be that depending on what comes out of that medical advice, you decide not to take any further action at that particular point. Or alternatively, you may take the view that it's perfectly appropriate to proceed with the formal performance process. Needless to say, of course, getting that kind of advice can take time, and there is nothing to stop you putting in place performance improvement plans or doing some sort of less formal process in the meantime to try to resolve the situation. But you do need to tread carefully and certainly take account of what the employee has said to you so far. We've touched on this briefly already, but if the employee does have a disability, then it is possible that a reasonable adjustment might be not to issue a formal warning on a particular occasion. Again, especially if the employee's previously been a strong performer. Having said that, even if you decide not to go as far as a formal warning, it's really important that you still make a record of the conversation that you have had, and to make sure that that is kept on the employee's file in case you need to refer to it further down the line. And that really goes for any informal discussions around performance or underperformance as well. As I say, you need to be considering in a disability context whether there are reasonable adjustments that you should be making to help the employee improve their performance. And in the context of reasonable adjustments, you will know that that word reasonable pops up again. So it depends very much on the circumstances, the nature of the underperformance, the impact of the business, the size of the business, etc., etc. So there is no absolute right or wrong way. It is just important that you consider all those different factors when deciding whether or not an adjustment is reasonable, and whether or not that adjustment is likely to have any positive effect on the employee's performance. In the end, though, as I say, you are not, as an employer, required to put up with materially substandard performance merely because it is the product of a disability. If you consider and take if you make reasonable adjustments and those adjustments still do not lead to any improvement in the employee's performance, then your rights to warn and potentially eventually dismiss if performance does not improve are exactly the same as they would be in any other case. Bearing in mind what I said about the difficulties that managers sometimes have in dealing with mental health issues, it is good practice to try to ensure that managers receive training in relation to mental health, so that when they encounter employees who express concerns about having these sorts of difficulties, they feel confident in managing them and in bringing the right people into that conversation at the right time. Managers who know their staff well and who are regularly catching up with them, whether that's through one-to-ones or anything else, if they've had that training, they are going to be better placed to be able to spot signs of poor mental health at an early stage. And it's one of those things that the sooner it can be picked up and the employee supported, the more effective that tends to be. But there are certainly various reports that make clear that the inability or the lack of confidence in dealing with these sorts of issues, which mainly stems from a lack of training, can affect the managers themselves. And so it is really something for you to consider. Okay, I'm going to hand back to Will now just to talk a little bit about what happens if an employee raises a grievance or brings some sort of discrimination complaint during a performance process.
Thanks, Jeanette. So, needless to say, some employees don't respond well to their employer's efforts to improve their performance, to put it mildly. It's not unknown for employees to react to even informal performance management discussions by accusing their manager of bullying them, harassing them, or of otherwise discriminating against them in some way or other. This can be a tricky situation, but there are ways of dealing with it which should still allow you to move forward and manage the employee effectively. We don't have sufficient time today to go into detail about how to handle allegations of bullying or harassment generally, but the safest first course of action will usually be to adjourn the performance management process until the allegations have been investigated. That probably means concluding the almost inevitable appeal if the allegations are not upheld. In cases in which such allegations are made against the employee's manager, a proper paper trail is particularly important. A lack of documentation can be of a special concern where employees are dismissed for poor performance and claim there was a discriminatory reason for their dismissal. In such cases, the absence of documentation pointing clearly to any non-discriminatory motive could leave a vacuum in the manager's reasoning, and that could in turn lead a tribunal to infer that discrimination has taken place. It's always important to remember that in discrimination cases, the burden of proof means that the employer is effectively guilty until proven innocent. That means that if you can't prove the poor performance upon which you rely, you're likely to lose. Relatedly, the Equality and Human Rights Commission's Code of Practice on the Equality Act contains a helpful section on avoiding discrimination when conducting appraisals. The EHRC recommends that employers make sure that performance is measured by transparent, objective, and justifiable criteria using procedures that are consistently applied, as we've said. Check that the performance of all workers is assessed against standards that are relevant to their role. Well, yes, obviously. Ensure that line managers carrying out appraisals receive training and guidance on objective performance assessment and positive management styles. And monitor performance assessment results to ensure that any significant disparities in scores apparently linked to a protected characteristic are investigated and steps are taken to deal with possible causes for this. Now, it's important to note that following these recommendations in all cases isn't by any means an absolute requirement, and there will be situations in which it's necessary or reasonable to depart from them. For example, as we've said, it might simply not be possible to measure an employee's performance using objective criteria in all cases. However, following the guidance as far as you reasonably can would certainly be best practice and help you to reduce the risk of discrimination claims. Could I have the next slide, please? Thanks. So another question which clients regularly ask is how to handle an employee who goes off sick with quote-unquote stress during a performance management process. Now, performance management-induced stress, a close relation of misconduct investigation-induced stress and redundancy exercise-induced stress, is a frequent occurrence when concerns about underperformance are raised, often arising in conjunction with allegations of bullying and harassment of the sort we've just considered. The business might well suspect that the employee is simply trying to delay matters, and might very well be right about that. However, it's always important that the employer is seen to be acting reasonably in the circumstances. Acting reasonably may include doing those things which are helpfully mentioned on the slide. First, postpone the meeting. If an employee has been signed off with stress in advance of a pending meeting, it won't be appropriate to press ahead with the meeting, at least not immediately. However, that isn't to say that you'll never be able to deal with the employee's performance issues, even if they remain absent from work for an extended period of time. Second, at least try to speak to the employee. Try to find out the source of the employee's stress, as Jeanette said, and whether there are any steps you can reasonably take to address their concerns. If employees are stressed about having to attend a performance management meeting, you could, for example, allow them to take regular breaks, or conduct the meeting remotely, off-site, or even in their own home. You should explain to the employee that, whilst it's perfectly natural to feel stressed about such things as performance issues, they can't avoid the issue simply by staying at home. All that does is delay the possibility of reaching a solution and prolong their uncertainty and stress, so it's not in their best interests. If there are other factors at play, you should discuss these and consider whether you need to take any steps to address them. Third, as Jeanette has already touched upon, consider obtaining medical evidence. If the employee is unable or unwilling to indicate when they'll be in a position to attend a meeting, obtaining a medical report may be the best next step. Back in 2012, the Department for Work and Pensions issued very helpful guidance to GPs and occupational health professionals in its Health and Work Handbook on how to respond if asked to give an opinion as to whether an employee is fit to attend an investigation or disciplinary hearing. Very encouragingly for employers, it stated that it is likely that the effects of an unresolved dispute on the employee's mental health may be greater if the proceedings are postponed. An employee may be unfit for work, but fit to engage with the management process. The doctor or nurse will have to assess whether attendance is likely to cause serious deterioration in the employee's mental or physical health. The guidance went on to suggest that the following questions may be used by health professionals to determine the fitness of an employee to attend a disciplinary meeting or otherwise engage with the management process. Does the employee have the ability to understand the allegations made against him? Does the employee have the ability to distinguish right from wrong? Is the employee able to instruct a friend or representative to represent his interests? And does the employee have the ability to understand and follow the proceedings, if necessary with extra time and a written explanation? Now, this is clearly a much higher threshold of incapacity than an employee feeling a little bit under the weather, slightly stressed, or wanting a bit more time to collect his thoughts or consider his options. We haven't been able to locate an updated version of this guidance, but it's clearly still relevant and may well be worth quoting when seeking a medical report in such cases. So as a final point from me, we thought it was worth mentioning employees who work remotely in light of the increasing numbers of staff doing so in recent years. Remote or hybrid working can potentially make it harder to manage performance, but this doesn't generally have to be the case. After all, unless you need to be able to physically watch your employees to monitor their performance, it should be entirely possible to devise appropriate performance management processes for remote employees. That being the case, some studies have suggested that remote workers are more likely to get lower performance reviews, smaller pay increases, and fewer promotions than their colleagues who work in the office, even if they work just as hard, just as well, and for just as long. With that in mind, it's important to ensure that your managers maintain equality between remote and in-person performance management processes so far as possible, to avoid the risk of grievances or discrimination claims. Women, especially those with children, and individuals with disabilities may be more likely to request hybrid or remote working, and so may be disproportionately affected by performance management processes which are less favourable to remote workers. Things to consider in this regard include the importance of regular, ongoing and transparent performance feedback. In some roles, such as sales positions, monitoring and providing feedback may be relatively straightforward. In other roles, the means of measuring performance may be less obvious, so thoughts may need to be given as to the best way of doing this. You'll also need to ensure that you have the right processes in place to induct and train up new joiners who work remotely, particularly those in roles where much of the learning is on the job. Where underperformance arises, remote working may also make it more challenging to provide additional support, training or supervision, though again, this should only be the case where such support, training or supervision needs to be provided face-to-face. I'm now going to hand back to Jeanette, who's going to discuss the possibility of a Plan B, where beginning or continuing a performance management process is an unattractive proposition.
Thanks, Will. Yeah, so this question comes up quite a lot because let's face it, having these sorts of conversations can be quite difficult. And as I said right at the beginning, they can take up an awful amount of management time. And so the question we're asked is, can we just have an off-the-record chat? Well, let's just talk first of all about what we mean by an off-the-record chat. As you know, there is the possibility of having that kind of conversation in the context of what we call pre-termination negotiations, which is a specific context and framework, if you like, to have that kind of conversation without it being on the record. There are limitations, though, to what we call the Section 111A pre-termination negotiation conversations, because they only will be kept off the record if the potential outcome is an ordinary unfair dismissal claim. So what I mean by that is if there is any potential scope for an automatic unfair dismissal claim, or, for example, there are breach of contract allegations or discrimination allegations, they fall outside of the scope of Section 111A. And so you would be taking a risk if you were to use that kind of route to have that off-the-record conversation. There is still the potential for an ordinary, without prejudice conversation, the good old-fashioned way, if you like. But there are, again, some potential limitations there, because in order for without prejudice to apply, and again, without prejudice means that it is essentially off the record. So if ultimately you couldn't reach an agreement and you did end up in litigation, the employee would not be able to bring this without prejudice conversation to the attention of the tribunal. And that's because there are two factors that apply. The first is that there has to be a dispute between the parties, and secondly, that there is a genuine attempt to try and resolve that dispute. Now, one of the tricky things, particularly in relation to a performance management conversation, is whether or not there's actually a dispute. If you've just had a conversation and there's some acknowledgement that the performance isn't good, etc., then it's less likely that a dispute exists in those situations. So you don't have that hook for the without prejudice conversation. On the other hand, if there is a standoff, if there's a threat to take things further, then it may well be that you can tick that box. Taking a step back, though, whether or not you have the basis for some sort of off-the-record conversation, I think you do need to think carefully about whether or not that's the right thing to do if an employee is underperforming, particularly where you have evidence to support that. What you want to avoid doing is starting off or setting a dangerous precedent, which employees become aware of, that where there are performance concerns, they could potentially get some sort of package rather than being taken through a formal management process. There are obviously pros and cons, and again, it's one of those things that I think you need to think about in the particular context, and there could be any number of reasons why there's a bigger business interest in being able to resolve things quickly so that the manager can concentrate on other things. But as I say, there is always that danger of that unfortunate precedent. And just to finish, a very quick reminder that certainly as things currently stand, of course, generally employees have to work for 2 years before they gain the right to claim unfair dismissal. There are, as we've touched on already, some circumstances where that doesn't apply. And so, but there would be in cases where you're dealing with either whistleblowing or discrimination. Because of that, it's really important that you have documentation which shows that you had concerns about the performance and that you were taking steps to address it. Because if you're able to do that, it is much harder for the employee to show that the management of their performance was in some way, shape or form retaliation for their either having brought some sort of complaint or that they were being treated less favourably for some reason. And I think one of the other things I would just highlight there, and it's mentioned at the top of the slide, is that where you have new employees coming on board, you really should try to make good use of the probation period and in effect manage it in the same way as you might a poor performance process or review period, in that you pick up concerns about the performance early, you're seen to be having regular dialogue, you are setting the objectives, etc., and you're documenting all those steps so that if you decide during the probationary period that things aren't working, that you have the evidence to support that, as I say, just in case they try to bring some sort of discrimination or whistleblowing claim. And obviously with the change to the day one rights, or rather making unfair dismissal a day one right announced by the government as part of its employment rights bill, the focus on that statutory probation period, which we think will be 9 months or so, it just reinforces or reignites rather the importance of focusing on managing performance during that initial statutory or that initial probationary period. Okay, that brings our session today to a close. So it just remains to be said my thanks to you all for participating. We have had a number of questions. I'm afraid, unfortunately, we haven't had a chance to answer those, or not all of them at least. So we will pick those up. And if you have any other questions, please feel free to drop them into the chat as you have been, or alternatively speak to whoever it is on our team that you usually deal with. And as I mentioned at the beginning of the session, we will be circulating the webinar slides and a link to the recording of the webinar. So please do keep an eye out for that. So thanks again and have a good rest of the day. Bye-bye.